A major ruling from the nation's highest court landed quietly, and a lot of people rushed to explain it without actually understanding it. That rush is dangerous. When legal decisions get flattened into viral soundbites, people start repeating claims that feel empowering but can actually backfire in real life. And in this situation, repeating the wrong interpretation could cost someone their freedom. Before getting into the details, let me ask you something simple. Are you paying attention right now? Because what you're about to hear is the kind of information that keeps people out of prison, not the kind that gets likes online. The headline floating around makes it sound like one sweeping Supreme Court ruling flipped both the right to speak freely and the right to keep and carry firearms overnight. That's not what happened. What really occurred is more subtle, more technical, and much more important. There are two different Supreme Court developments that people are mashing together. One involves firearms and restraining orders. The other involves speech and government pressure. They touch the same community, but they are not the same case, not the same facts, and not the same legal rule. Confusing them is how people end up believing myths that feel comforting right up until the moment they're standing in front of a judge. Let's start with the firearms decision, because that's where the most fear and misinformation is coming from. The case involved a federal statute and a man I'll authorize Coleman. He wasn't convicted of a violent felony. He wasn't part of an organized crime ring. He owned his firearms legally, but during a volatile domestic dispute, a court issued a protective order against him. That court didn't just issue a generic warning. It made a specific finding that he posed a real and immediate risk to another person's physical safety under federal law. That kind of finding triggers a temporary prohibition on possessing firearms while the order is in effect. Coleman argued that this law violated the Second Amendment in every possible application, not just in his case, but always. The Supreme Court disagreed by an overwhelming margin. 8 justices said that when a court has formally determined that someone presents a credible threat of violence, temporarily restricting access to firearms does not violate the Constitution. One justice dissented. That's it. Not a split down ideological lines, not a razor-thin margin. An emphatic majority. Now here's where people start getting it wrong. The court did not say that the right to keep and bear arms has vanished. It did not say that anyone accused of wrongdoing automatically loses their rights. It did not give governments permission to disarm people on a whim or based on rumors, politics, or vibes. The ruling was narrow. It applied to a specific legal framework involving protective orders, judicial findings, notice, and due process. The difference between a narrow ruling and a sweeping one is everything, and pretending they're the same is how bad advice spreads. This case also matters because it builds on an earlier decision that reshaped gun law nationwide. A few years ago, the Supreme Court told lower courts to stop using interest balancing tests when judging firearm regulations. Instead of weighing public safety against individual rights like items on a scale, courts were instructed to look to history and tradition. That earlier ruling caused chaos. Some judges began demanding near-identical laws from the 18th century to justify any modern regulation. Others applied the standard more flexibly. The result was a patchwork of decisions that made outcomes unpredictable. In the Coleman case, the Supreme Court stepped in and clarified something crucial. The Constitution is not frozen in time. Judges are not required to find a carbon copy of a modern law sitting in dusty archives from 1791. What they are required to find is a historical counterpart in principle, a comparable tool, something that addressed the same kind of danger in a similar way. Without crushing the core right, the court explained that the real questions are why the law exists and how it operates. What problem is it targeting? How severe is the burden? How long does it last? Who does it apply to? That clarification matters far beyond restraining orders. It tells lower courts to stop playing historical scavenger hunts and start engaging honestly with constitutional principles. And yes, that approach can sometimes support regulations, but it can also invalidate them when they're too broad, too permanent, or to detach from actual risk. To make this concrete, imagine a man named Eric. Eric has no criminal record. He lawfully owns firearms. He carries responsibly. Then his relationship implodes. Emotions run hot. His former partner files for a protective order. Eric shrugs it off. He assumes it's just family court drama, civil, not criminal, paperwork, not punishment. He ignores the hearing. He doesn't read the fine print. He keeps his firearms, assuming common sense will prevail. That's where everything goes wrong. Because if the court issues an order, that includes a formal finding that Eric is a danger to someone's physical safety, federal law kicks in. At that point, possession alone can become a felony, not because Eric committed a new crime with a gun, not because he threatened someone with a weapon, but because he failed to understand how civil orders intersect with federal law. Temporary doesn't mean harmless. Temporary can still mean handcuffs, charges, court dates, legal fees, and long-term consequences that don't evaporate when the order expires. People ask how this can coexist with the constitutional right. The answer is uncomfortable, but long-standing. Rights are fundamental, but they are not limitless. Historically, American law has always included mechanisms to restrain individuals who pose an imminent danger to others. The court pointed to old legal practices designed to prevent violence before it happened, not just punish it afterward. Temporary disarmament of someone judicially found to be dangerous fits within that tradition. Another detail most commentators miss is the type of challenge Coleman brought. He wasn't arguing that the law was misapplied to him. He was arguing that it could never be applied constitutionally to anyone. That's an extraordinarily high bar. To win, he would have had to show that no set of circumstances could ever justify the statute. The court didn't need to imagine every possible scenario. It only needed to identify one clear, constitutional application. Once it did, the challenge failed. That keeps the ruling narrower than the internet suggests, and it preserves room for future challenges in different factual contexts. Now let's pivot, because the First Amendment didn't enter this story through that case at all. It entered through a separate battle over government influence and private actors. The issue there is simple in principle, but messy in reality. Government officials are not allowed to accomplish indirectly what they are forbidden to do directly. They cannot quietly lean on banks, insurers, payment processors, or platforms to punish lawful speech they dislike. When regulators hint, suggest, or imply consequences unless certain speakers are silenced, that's not neutral governance. That's coercion wearing a polite mask. This matters deeply for anyone involved in controversial but lawful activity, including firearm education, advocacy, commerce, and media. Shutting down speech doesn't always require a statute. Sometimes, it just requires making life difficult enough that organizations collapse under the pressure. When financial services disappear, when insurance evaporates, when platforms close doors without explanation, speech dies without a single law being passed. People who say they only care about the Second Amendment often miss this connection. The right to keep and bear arms doesn't defend itself. It relies on speech, association, fundraising, education, and organization without the freedom to speak and organize. Rights wither quietly. That's why these two constitutional lanes, while separate, frequently intersect in the real world. So what actually changed for the average person? A lot less and a lot more than the headlines suggest. One major lesson is that certain phrases in legal orders are not decorative. When a court writes that someone poses a credible threat to physical safety, those words carry enormous weight. They can activate federal prohibitions that people don't see coming until it's too late. Another lesson is that process matters. Notice matters. The opportunity to be heard matters. Ignoring a hearing or assuming it's meaningless can be the very thing that makes a restriction lawful. Temporary measures can still wreck lives if they trigger criminal liability. Even if someone ultimately prevails, the damage done along the way can be permanent. The historical test for firearm regulations is still the law of the land, but it's now clearer how it should be applied. Courts must engage in good faith comparisons, not demand impossible precision. That instruction cuts both ways, and anyone who cares about constitutional rights should want consistency over chaos. Speech protections are also not abstract. They affect real businesses and real people. A firearms instructor losing insurance, a small manufacturer losing banking, a content creator being quietly deplatformed. These aren't hypotheticals. They're modern pressure points, and courts are starting to scrutinize them more closely. Here's an uncomfortable truth that deserves to be said plainly. Many people lose rights without ever committing violent crimes. They lose them through paperwork, silence, assumptions, and moments of anger that feel private but become permanent records. The law doesn't care how reasonable you usually are. It cares about what's written after, what's ordered, and what you do next. Imagine a traffic stop after a long day at the range. Everything is legal, but nerves take over. Words spill out. Movements get sloppy. A situation that should end with a warning becomes tense because panic. replaces calm. Rights aren't exercised by bravado. They're preserved through discipline and awareness. Imagine a breakup spiraling into texts that feel cathartic in the moment. Not threats, just anger. Then a piece of paper arrives. A hearing is scheduled. The judge doesn't see context. The judge sees exhibits, words on a screen. If the resulting order includes certain findings, the legal landscape shifts overnight. Imagine running a small, lawful business connected to firearms, no crimes, no violations. Then services start disappearing, no explanations, just polite silence. That's not a conspiracy theory, it's a known tactic, and it's why speech protections remain vital. Some myths need to die. This ruling does not mean accusations equal disarmament. It does not mean the government can label anyone dangerous and strip rights at will. The court emphasized findings, process, and limits. That doesn't mean abuse is impossible. It means the constitutional analysis depends on specifics, not slogans. Here's another hard truth. When you own firearms, you have more to lose in moments of conflict. The law treats mistakes differently when weapons are involved. That's not fairness or unfairness. It's reality. Being cautious isn't weakness. It's self-preservation. Looking forward, this decision will shape how future gun laws are argued. Courts will focus on whether regulations are narrow, targeted, and tied to demonstrated risk, or whether they're broad, permanent, and based on categories rather than conduct. Laws that sweep too widely will face stronger challenges. Laws that mirror historical methods of addressing real threats will be harder to attack. Picture a law that bans firearm ownership for anyone who has ever sought mental health treatment. Most people instinctively feel that's wrong. Under the framework reinforced here, courts would ask whether the law targets actual danger, whether it allows individual assessment, whether it's temporary, and whether it respects due process. That's where these fights are headed. If there's one lesson worth carrying forward, it's this. Rights are rarely lost in dramatic confrontations. They're lost quietly through neglect, misunderstanding, and bad advice shouted the loudest. Online, the Constitution is powerful, but it doesn't protect people who refuse to engage with reality. Staying informed matters. Precision matters. Treating legal issues like gossip can destroy lives. And assuming safety because you've done nothing wrong is a mistake the law does not forgive. This isn't legal advice. Laws evolve. Facts matter. Jurisdictions differ. Anyone facing a real situation needs real counsel, but understanding how these decisions actually work instead of how they're marketed is the difference between protecting your rights and accidentally handing them away.